Welcome to day one of Family Mediation Week, and thank you for joining our webinar on hybrid mediation. I'm Sarah Manning, Chair of Family Mediation Week, and I'm delighted to be here alongside my fellow presenter, Elaine Richardson. We have an hour to explore this important topic, and there's a lot to cover. Rest assured, you'll receive a copy of the slides following the session. Next slide, please. So I'm a partner and head of mediation at Hall Brown Family Law. I qualified as a family solicitor in 2011 and trained as a mediator in 2012. These days, I dedicate the majority of my practice to mediation, specialising in hybrid mediations for high net worth individuals in both financial and children-related matters. Additionally, I'm qualified to speak directly with children as part of the mediation process. As mentioned, I've been the chair of Family Mediation Week now for the past 4 years, and I'm also a member of the Dispute Resolution Committee and Northern Lights, which is an organisation organising a DR conference in the north. Next slide, please, and over to you, Elaine. Thank you.
Morning, everybody. By way of background, I'm a trauma-informed family solicitor, and I did my trauma-informed training with the Law Society of Scotland. I run my own business as an accredited child-inclusive hybrid mediator. All of my mediations are online, and I work with people across the country and abroad. I also supervise other mediators as their professional practice consultant, their PPC, and I supervise family lawyers as well as their family law supervisor. I'm a trainer and presenter, and I specialise in training on domestic abuse, safeguarding, and high conflict. I've been a member of Resolution, which is an organisation of family justice professionals, for over 20 years, and I'm now co-chair of Resolution's National Dispute Resolution Committee. I often mediate high conflict disputes, and I've been trained to do so by the High Conflict Institute of America. Next slide, please.
Thank you. I just want to go quickly over the session objective today and what we aim for. So to explain hybrid mediation and the benefits to you, to identify suitable cases with some real case examples, and to give you our top tips. And at the end, we will answer any of your questions that you have. Thank you. Next slide. Before we begin, I just want to go back to basics and start by recapping on the definition of mediation. Which is a process in which those involved in family breakdown, whether or not they are a couple or other family members, appoint an impartial third person to assist them to communicate better with one another and reach their own agreed and informed decisions concerning some or all of the issues relating to separation, divorce, children, finance, or property by negotiation. Mediation is based on a number of principles that I just want to recap with you. The mediator remains neutral, impartial at all times and does not take sides. The information shared with the mediator is kept confidential with some exceptions. The parties involved in the mediation are responsible for finding a solution, and it's a voluntary process. Mediators encourage people to listen actively to each other and to consider different perspectives. Next slide, please.
So we wanted just to give a shout out for these changes that took place to the family procedure rules on the 29th of April last year. So here's a 9-point summary of the new rules in no particular order. I'm not going to read the whole slide, but I want to highlight that the new rules widen the definition of non-court dispute resolution, NCDR, so that as well as mediation, there's now the specific inclusion in the definition of arbitration, neutral evaluation, and collaborative law. And PD3A paragraph 9 states that a mediator who conducts a mediation information and assessment meeting, a MIAM, is a qualified independent facilitator who will also discuss all potentially suitable forms of NCDR. So accredited mediators undertake MIAMs, and you can do a search on the FMC website to find one. Another thing that I wanted to highlight about these changes is that there will be court scrutiny of MIAM attendance and beefed up costs orders in financial proceedings for failure to consider attending a MIAM or participating in NCDR. In other words, judges can make costs orders against parties who do not get involved in NCDR when it's suitable to do so. We've got the pre-action protocols, which is great, so that everyone knows that best practice is to consider NCDR first, in most cases involving children and/or finances before going to court. And we also now have the President of the Family Division's letter about making court applications about children, and that also emphasises NCDR first. So very often I will share with mediation participants the pre-action protocols and the President's letter. And as you know, the meetings in the mediation process fall into two types. So firstly, as I've said, the pre-mediation assessment meetings, which are often known as MIAMs, and secondly, the mediation meetings themselves. So over to Sarah now to describe MIAMs. Next slide, please.
Thank you. So for me, the mediation information assessment meeting is the most significant part of the mediation process. The MIAM serves three key purposes: to provide participants with detailed information about mediation, to allow the mediator to assess whether mediation is a suitable method for resolving the dispute, and to give the parties an opportunity to decide if they are willing to proceed with the joint session. I just want to highlight there that mediation is voluntary and not compulsory to go on to the joint sessions. And it's often called, I refer to it as a suitability and willingness test, whether it's suitable and also whether the parties are willing to attend a joint session. The MIAM follows a standard and has to last at least 50 minutes, during which the mediator provides participants with comprehensive information about the mediation process and other non-court dispute resolution options. So the days of 10-minute MIAMs have long gone since the introduction of the new standards. This enables participants to make informed decisions about how best to resolve the issue they are facing. Additionally, the meeting offers the mediator a chance to speak confidentially with each participant to understand their individual circumstances, identify key issues arising from the separation, and evaluate the safety and suitability of mediation. It is equally important to discuss the value of seeking independent legal advice during this meeting. I think one of the things that crops up on a lot of my cases that have mediation is that the solicitors have already deemed mediation unsuitable and they're just coming to myself for sort of the box to do the form, and we still have to go through a thorough assessment ourselves and the session to go through that with the participants. As part of the assessment, the mediator must gather sufficient information about the participants' relationship before and after separation, how they interact with the other one, and this impacts on how it impacts on any children involved. Assessing safety and suitability is a critical part of this process. The mediator is able to triage if other professionals need to be involved in the process at that early stage. This could be a solicitor if the participant has not obtained legal advice. It could be a divorce coach or therapist or counsellor if they require emotional support through the process, or it could be a domestic abuse agency that you refer to. It may even be identified that a pension and divorce expert is required or a business valuation, and we can talk through that at that time when we spend time with them each individually. By the end of the MIAM, it's important that participants leave with a clear understanding of their next steps. This may include signposting, as I said, and services to outline a plan based on the issues discussed. I often receive referrals from MIAMs where participants are at very varying stages of the separation. For some, the MIAM is the starting point of the journey, and I may recommend sort of more of a planning meeting where both participants receive the same legal information and discuss how they both wish to formalise their separation collaboratively. Or in other cases where I work with participants who have already had legal advisors, they might have already exchanged financial disclosure or already partway through a parenting plan or something, and it can be more cost-effective option for coming through mediation, as it provides a neutral environment for discussions and reduces the reliance on written correspondence, which can sometimes escalate tension and cause delays. I also receive referrals where one participant is considering initiating court proceedings as they've got a bit exasperated with the time delay, and as part of the pre-action protocol is required to attend the MIAM. But in such an instance like that, we can explore the possibility of mediation running alongside the court process, offering the structure and security of the court timetable while working to resolve matters as efficiently as possible. We're not going into too much detail about the MIAM now. We just wanted to pass on them key points, and there's a report on the slides there that you can click on to get some more information. Thank you. Next slide, please.
So turning now to hybrid mediation, and you'll see the bullet points on this slide: trained mediators, holding confidences, separate spaces, often supported by lawyers, support from other family experts, and it being flexible and bespoke. And again, there's a link there to an article about hybrid mediation in detail. So hybrid mediation is an advanced form of family mediation, and it's flexible and bespoke. And the name stems from combining elements of the civil or commercial mediation and family mediation models. The hybrid mediators have specific training in the hybrid process, and the Resolution Hybrid Mediation training course was launched in 2018. As well as in-person meetings, many of the trained hybrid mediators offer hybrid mediation online, which I do, which means that all 5 mediation participants, the mediator, the 2 clients and the 2 lawyers, can be in different places across the globe when the meetings take place. So, for example, at the moment, I've got a case where one participant is in Australia. I've got another case where both participants are in New Zealand, and the only thing you have to watch out for is the time difference. So hybrid mediation works for all kinds of situations, complex and more straightforward, high or low conflict, and as with all mediation, it's confidential and private. So 3 notable elements of hybrid mediation are an agreed level of confidentiality to assist the negotiations, mediating using separate spaces, sometimes known as shuttle mediation, and the proactive and direct involvement of lawyers in the process. And although hybrid is often known for involving lawyers and sitting in separate spaces, the reality is that these 2 possibilities can take place in traditional family mediation as well as hybrid. So the only difference between hybrid and traditional mediation is the keeping of confidences. So hybrid recognises that individuals can agree together the level of confidence that will apply to their mediation. That's Family Mediation Council Code of Practice 6.5.3. The difference between traditional family mediation and hybrid is that the hybrid mediator is trained to hold certain confidences in respect to the negotiations. And the hybrid agreement to mediate contains the confidentiality clause, and this agreement to mediate is signed by all the mediation participants before the mediation starts. This means that the participants can explore options with the mediator in the privacy of their room in a caucus, and individual legal advice can be shared confidentially with the hybrid mediator by lawyers directly or through their clients, so that the mediator is then in a unique position to recognise areas of consensus and can use this knowledge to facilitate compromise. So during the negotiations, the mediator can be given consent by each participant to share details of the proposals and compromises they're prepared to offer when the mediator finds the best opportunity to do so. The mediator can identify any overlap in proposals and encourage settlement. So obviously, if you're going to share a confidence with the mediator, you would need to be sitting in a separate breakout room. And so they can confidentially explore the options and discuss possibilities with the mediator before putting forward proposals to the other participant. And of course, if lawyers are in the mediation meetings, they sit together with their client in a separate breakout room, whilst always having the opportunity to meet separately with the other lawyer and the mediator. So the involvement of lawyers. Lawyers' support can be both direct and indirect in hybrid mediation. Sometimes lawyers attend the hybrid mediation meetings from the outset, sometimes not at all. Sometimes the separating couple will opt to have a few mediation meetings first without lawyers and then bring their lawyers into the meetings when negotiations commence. When lawyers attend the mediation meetings with their clients, the lawyers advise and support their clients in real time. And when lawyers do not attend the hybrid mediation meetings, often due to financial constraints, their clients can obtain advice and support from them before and or after the mediation meetings. And lawyers can assist, of course, in preparing relevant information such as Forms E, asset schedules, parenting plans, heads of agreement, and consent orders. So if lawyers attend the final mediation meeting, they can draft the outcome documents immediately after consensus is reached based on their own direct knowledge gained during the hybrid mediation meeting. Next slide, please. So This just shows the stages of hybrid mediation, and it's often the order of events in a hybrid mediation process. The client always has choices, including if and when lawyers take part in the mediation meetings. During hybrid mediation, when lawyers join the process, there is the addition of a professionals meeting, and this is a collaborative planning meeting between the mediator and the lawyers without their clients. It's an opportunity to meet the mediator and the other lawyer. The mediator checks that everyone knows about the hybrid process and what their role is, and the mediator and the lawyers discuss the practicalities, share information, provide updates, and discuss the potential sticking points. So the professionals meeting enables the mediator and the lawyers to refine their preparations. So the cost of hybrid mediation, just like traditional mediation, varies depending on the mediator's hourly rate or fixed fee charges, and the costs are often shared equally by the participants, or they can be paid by one person. So when is it appropriate? Although hybrid is appropriate for any issue to be mediated, it's particularly suited to complex issues. It's also suited to where there's a power imbalance, known or possible personality traits or disorders, making it hard to reach agreements, known or possible neurodiversity, impacting the process of information, and if there are urgent matters where negotiations are stuck, when a person wishes to have a legal advisor with them during the negotiations, in high conflict cases, and cases where domestic abuse is a concern. Often, a participant will simply need the space, time, and advice to reflect on ideas and proposals being put forward, to respond to them thoughtfully and effectively. And importantly, and often overlooked, hybrid mediation is well suited to taking place at the same time as a court application, as Sarah has said. Back to you, Sarah.
Thank you. So I'm just going to talk about the benefits in high net worth and complex cases of the mediation, because obviously we've still got the traditional mediation where you'd get the husband and wife or the participants to be together. One of the key advantages of hybrid mediation is the ability to involve other professionals when needed, creating a supportive team around the participants to help them reach a workable solution. This collaborative approach enables informed decision making and fosters a more constructive path towards resolution. Having supportive lawyers who understand and respect the mediation process is critical. In one case, I reached a point where I encouraged the participants to seek legal advice, which happened recently, and the issue at hand was a disagreement over spousal maintenance, and specifically whether it should be paid, and given the disparity of the incomes, because they'd not had active engagement with the solicitors, I'd said to them both, "You need to go speak about spousal maintenance." And at that point, husband's looking at me like, "Why have you mentioned spousal maintenance?" And wife's looking at me thinking, "Oh, what's this with to do?" But because I could give them legal information, but I couldn't give them their specific advice. So I said to go to speak to their solicitors. It is a challenging decision, as many participants want to achieve a clean break. And that was their main point. But I thought it was important and crucial that wife did go have that legal advice to hear to make an informed decision then as to what she wants to do. And I advised them to consult their solicitors, and we sort of stayed the mediation until they'd gone and done that. But what was interesting is when they'd come back into the mediation setting, I could see that it was very that they hadn't been working well. There was lots of tension. And the wife had spoken to her solicitor, who, instead of providing advice to be discussed in mediation, went ahead and drafted a letter demanding immediate spousal maintenance. I asked them in the session if I could have a look at the letter, because I wasn't sent it before. So I was just faced with this situation in mediation. So the solicitor hadn't sent me a copy of the letter either. And then the only letter that the client had was a draft copy that she'd been sent, and it still had an X in the figure for what she'd asked for spousal maintenance. Husband couldn't remember what figure it was. She couldn't remember what figure it was. So, and then wife says, "But in any event, I don't want spousal maintenance." So then I was, "Well, why did you ask your solicitor to do it?" Well, I just wanted him to know that I was entitled to spousal maintenance and that he knows this is a fair decision. So once I'd sort of unpicked that and unravelled what had happened, they both said that they still wanted to proceed on the agreement that we'd set, but without spousal maintenance. And just by the solicitor, that lack of engagement and working together of that letter going forwards, just undid a lot of the good work that we'd done in mediation. It took me that session to get us back on track. And it's not to say we're ignoring the advice the solicitor had given, but it's listening to your client, which I think is important, and the process that they've chose to to take part in to reach a settlement, because there was very amicable, and even when we reached an agreement, there really has. So I think one of the important for me is it's really important with what role the legal advisor is playing in the process. So sometimes what I've tried to do now is have more smaller professional meetings, even if the husband and wife are not having solicitors actively in the sessions themselves, have smaller professional meetings afterwards if we still need that active engagement from solicitors to make sure there's not the protracted correspondence where the message is often lost. The purpose of the legal advisor is often not fed back, and it's crossing communications, and the clients are usually in an anxious state having to come and discuss what's happening. It's hard for them to pick out the key points and then digest and what the next steps are, even with the best will in the world with a clear, detailed record session. So I think sometimes I've managed to, adapt my process of asking the clients, what would you prefer to do? And a lot of the times they'll say, oh yes, if you have a chat with my solicitors first, with both of them there, and then they can do a meeting. And often I think it saves money as well, because you've not got a lengthy meeting with your client trying to unpick what actually was said in the mediation, because I'd be able to say that quite succinct to legal advisors. The role of a solicitor is hard, and I know only too well that in order to give clear advice as a solicitor myself, you need to obtain, you always say, full and frank financial disclosure to give advice, and lots of questions for disclosure. And I understand that that's difficult, but sometimes in mediation we can look at things on a without prejudice basis. And sometimes, yes, we could, if you were in court proceedings, you would do a really detailed questionnaire. But sometimes in mediation, we can look at things on a without prejudice basis and say, right, yes, we both know that you're going to ask these questions later on, but is there an outcome we can do now to save time, and try reach a resolution without the need of court proceedings, and just be more focused on the not focus on the smaller issues, and we need to be cost proportionate. We need a joined up approach, and I would prefer for, like I say, the professionals only meeting, and sometimes that can really help. I had another case as well recently where both went for MIAMS, and it had come through, and husband really wanted to issue court proceedings. When he'd sat with myself for about an hour and a half, he realised that actually he really liked the idea of the hybrid mediation, having solicitors, and he didn't want to go to court, but he was quite frustrated with wife. So he said, if she comes forward for her MIAM, then I would be willing to attend a joint session, but I want my solicitor there. So wife had come and she said the same, and then we set up for a hybrid mediation. But what had then happened is, when I invited the wife's solicitor to come for a professionals only meeting, I got an email back saying there's no point proceeding this until we've got the disclosure exchanged and answer to the questions. So I says, why don't we have a professionals only meeting, even for 10 minutes, where we agree a timetable and dates to do it? And the solicitor said, no, I'm not willing to have any discussion until we've done that. And then ultimately I got an email from the husband saying, my solicitors, can we just have the court form to issue proceedings? So sometimes it's thinking about that situation and the other options. And it's obviously hard for me because I didn't know what discussions had had on there, but he initially wanted to go ahead with the hybrid mediation. I've also done, when we're talking about other professionals involved, I've done a lot of cases with independent financial advisor with the cash flow modelling, which I think is a really useful input into the mediation. The parties are able to see visually the proposals that are being put forward. I've had a recent case where it's very amicable between husband and wife that come together to the mediations, and we'd been working through things for about 6 months because there were different reports that we needed to get. And the cash flow modelling, with the financial advisor were able to be there and put in different information and put into the interim proposals that we was discussing of what it would look like for husband and wife. And their main part of what their outcome was that it was fair to both of them, but there was a real disparity of income. And that was one thing that that we were able to see, that actually visually when they put it in, it wasn't fair for wife, and we were able to adjust that. And that it was the parties still in control, saying, well, what could we do to make it fair or to make them a bit more even? I just wanted to read out one of the feedbacks I got from one of the solicitors involved in that situation. They put, Sarah had sought the early involvement of a financial neutral, which was a great assistance to the family involved. A case that could have involved months and months of protracted correspondence and potentially even litigation was resolved on the day. the parties left as friends and having felt heard, supported, and overall a huge sense of achievement and relief. So I think that I just wanted to read that out and just say that, you know, there is other ways that we can do it. It was a bit complicated in other in matters in terms of spousal maintenance and pensions and things, but there is ways that we can all come together and look at how we can deal with that. Another example of using other people in the hybrid process is for business valuations. Often when you do the disclosure, husband or wife will just produce a letter from their accountant saying what is valued, and you end up with streams of questionnaires in proceedings. Well, sometimes what I find works really well is that it's not that they don't believe what they're saying, it's just that they want someone independent to look at it. So getting a forensic accountant to come into mediation and do a business valuation, I think really works really well. And it's not to, and the way that we structure the questions is not that you think that they're not believing them or that they're lying or they're trying to defraud what the value is, but just having a more joined up approach, saying, can we just have someone independent look at and collaborate what you're saying, which works really well. I'm also dealing with financial advisor at the minute and a pension on divorce expert about dealing with SAS's pensions, and even though wife wants to leave the company alone, there's a SAS which the company has a commercial property involved in the pension. It's really complicated, but just inviting a pension on divorce expert to come and explain to the clients and what we can do is really helpful, of having that joined up approach rather than correspondence back and forth. I've also done a few session meetings recently, which is not tends to be the norm of the hybrid mediations, but just to say that this is something that you can do, is where you have barristers and solicitors present. So on one that I did recently, there was barrister, solicitor, client in one room, the same in the other. We had lots of meetings before professionals, but in that case, they'd done a lot of the legwork beforehand. They'd got a bundle together, a bit more like court bundle, and they just decided, let's just have a full day with the help of a mediator going back and forth to try reach an outcome. And we did end up doing that without having to go to court. The costs had already got a bit out of control in terms of legal meetings, and both of them were able to feel heard, got things off the chest that they wanted to say, but they never actually saw each other for the day, and they both left really pleased with the outcome. Because I think it's really important in mediations that you come out without an outcome that you can both reasonably live with. Myself and Elaine had recently worked on a case where I was acting for the wife as a solicitor and Elaine was the mediator, and there was another solicitor who represented the husband, and we were able to have a series of professional meetings and a joint session and have without prejudice discussions and explore options, and we were pleased that we managed to settle that, both reaching an outcome. And as a solicitor, it was a breath of fresh air dealing with that case on that basis, and I think that everyone involved just felt it was a really and there was some really complicated issues in it, and it could have exploded in litigation, but the legal fees would have outweighed what we was discussing, and we were just able to have more open discussions, and it was really nice to work all together on that matter. Another example is about children matters. You can use independent social worker to assist to avoid lengthy processes, or they can assist with supervised contact and work together to create a parenting plan. You can also have therapists come into the mediation and give feedback if they're working with the family. So there's a lot of things that we can look at in terms of the hybrid mediation and find out what is the issues at hand and how can we address that. So there is other people that can be involved, and sometimes it's just about having a divorce coach or therapist, because the other one participant's not quite at the stage of being able to make decisions moving forwards. So we just wanted to give some examples of how it can work with the more complex high net worth cases that ordinarily, especially as solicitors, it needs to go to court and just look a bit more outside the box. Right, back to you, Elaine. Next slide, please.
Thanks so much, Sarah, and for sharing those examples. I think it's important to be able to share how it works in practice. And I think that both Sarah and I just have such a positive experience of it. I wanted just to talk a little bit about hybrid mediation when domestic abuse is identified, and you'll see here the bullet points. So dealing with them in turn, points 1 and 2, the most important considerations, of course, are to remember at all times when working with victim survivors of domestic abuse that you always do no harm and keep adults and children safe and make safe choices. Bearing in mind, of course, as it says on the slide, that Risk is fluid and requires continuous assessment, not just one-off screening. So the Domestic Abuse Act 2021 defines domestic abuse as physical or sexual abuse, violent or threatening behaviour, controlling or coercive behaviour, economic abuse, psychological, emotional or other abuse, and the behaviour can of course be a single incident or a course of conduct. And under the Domestic Abuse Act 2021, it's really important to remember that domestic abuse is child abuse. So going back to that fluidity of risk, these assessments for domestic abuse must run like a thread throughout your work with a victim survivor. As I said, it's not just screening at the beginning of the work or a tick box exercise, it's a continuous assessment of risk. Point number 5, you need to be able to spot coercive and controlling behaviour, because otherwise we're not able to give the victim survivors access to justice. The voluntary nature of mediation should ensure that mediation is not entered into as part of the coercion of the perpetrator. Of course, knowing that coercive and controlling behaviour is the framework of all domestic abuse, and that it's behaviour designed to entrap somebody in a relationship. So bearing that in mind, my next bullet point is about making sure that your domestic abuse training is up to date, and good practice is to update that training every 2 years. And bullet point number 7, become trauma informed. Trauma informed practice is best practice and consists of the 5 key principles of safety, choice, collaboration, empowerment, and trust. Now, hybrid mediation offers an alternative to court in some domestic abuse situations. Going through the court process for the victim survivor of domestic abuse is highly likely to exacerbate the trauma already present due to the abuse. The drawbacks of going to court are set out in the July 2023 report of the Domestic Abuse Commissioner, called The Family Court and Domestic Abuse: Achieving Cultural Change. When someone has experienced trauma, one way to reduce that trauma is to offer choices, including which process to use. The coercive and controlling behaviour that's the framework of the perpetrators of domestic abuse negates autonomy, and therefore the choice of process provides autonomy for the victim survivor. So during traditional family mediation, the victim survivor of the abusive ex is completely exposed. They'll be trying to deal with all the controlling, coercive, abusive behaviours experienced during the relationship, whilst also trying to problem solve, negotiate, and find options for mutual gain. So if the assessment for abuse is effective, this kind of mediation meeting shouldn't happen. However, we know that perpetrators of abuse can be charming, successful, clever, persuasive, and subtle. So all family justice professionals may not spot them straight away, if at all. The coercive controlling perpetrator will be manipulative. Next slide, please. So compared to traditional family mediation, there's more time in hybrid mediation for the mediator and the participants to continue an ongoing assessment for abuse and address safety concerns through confidential conversations in separate spaces. And these assessments often involve considering the confidential information that's shared with the hybrid mediator, noticing the behaviour of the participants as the professional relationship develops, and continuing to challenge biases. So the behaviour of the perpetrator may not become particularly apparent when options are being options are being explored which do not align with the perpetrator's requirements. So from the perspective of the victim survivor of domestic abuse, these are some of the advantages of hybrid mediation. It can reduce CCB manipulation, gaslighting, and moving of the goalposts. There's immediate support and advice from their lawyer, with prevention of the undermining of their legal advice and team from the perpetrator. They can choose to be accompanied by a domestic abuse expert, an IDVA and ISVA, and that's under Practice Direction 27C. Deciding not to be in the same room as the perpetrator and being in a safer, calmer space of their own choosing, often online, allows for more thinking and processing time. It avoids the additional trauma and cost of going to court, which is often the worst place to be with a perpetrator. You regain autonomy, choice, control, and confidence as a victim survivor of domestic abuse by being proactive rather than reactive in making proposals. and you have the reassurance often that the perpetrator is being kept accountable by their own lawyer. So put an article on the resolution review. There's a link on the slide there just to continue looking at this. Next slide, please.
Thank you, Elaine. And I'm just going to talk about the impasse. Me and Elaine are both well aware that mediation does not fix all cases. And as a practicing solicitor, I know too well that in some cases you do need the court to make decisions, and especially in children matters, if there's safeguarding concerns, they need to be investigated. In some cases, participants just reach an impasse, and at this stage as a mediator, I would provide them with information as to their options for them to make an informed decision as to the next steps jointly. Often obtaining an early neutral evaluation can assist the parties to reach a resolution. An early neutral evaluation is similar to sort of a private financial dispute resolution hearing, and also it's usually by a barrister or retired judge. Can be with solicitors' involvement or not, as I can assist with that, and it can be as informal or informal as the participants like. I've been exploring a bit more recently in terms of the early neutral evaluation approach to be more cost effective, because if we reach an impasse, one of the issues they have is that they can't afford to then go to court proceedings, that they can't afford a private FDR, and it's looking outside the box of how we can help with them sort of cases. So one of the things I've done with our local barristers is talk about having like a neutral brief with conference with counsel, which often as solicitors we would do before you issue in proceedings to get that expert opinion. The barrister can come in and be as a neutral person with both of them and have a discussion, and it can be really informal, and something that I've been sort of testing out on some of my cases where they haven't got the funds to be able to do the full early neutral evaluations and more formal, a bit like a private FDR. In children matters, it is possible to have child-inclusive mediation where the child or children of the family are spoken to and have a voice in arrangements directly affect them. And you could also explore working with a therapist or independent social worker. They could also choose to both instruct collaborative lawyers, which is a non-confrontational way to resolve family issues, and a joined-up approach if they've reached an impasse, and that could be really helpful to seamlessly move on from mediation. The mediator can help also prepare neutral papers. So as I was saying about the early neutral evaluation, I can help provide like a neutral brief to them, setting out the details. But also we can always, so there's the option of arbitration. And before you go into arbitration, you fill out what's called an ARB1. And as a mediator, we can assist with liaising with the solicitors of what are the issues that need to be dealt with and determined by the arbitrator. The participants remain in control, only dealing with the issues that they have been asked to make a determination on in arbitration. Rather than in court proceedings, you're back to square one, and the court can make orders on all matters they see fit, even if the parties are in agreement. So I think it's a really seamlessly way to go is the arbitration from mediation, because if we've managed to tick off some of the box, we've got an agreed asset schedule, we've just got these issues. If you were to go to court, you'd be back doing financial disclosure. People sort of get very positional, asking further questions that there wasn't going to do in mediation, and we can have a discussions then and involve solicitors of what we're asking the arbitrator to do. We can also ask the arbitrator to determine on a discrete issue only. So if we've agreed everything else and it's just really in terms of spousal maintenance, not even the amount, but maybe the term, we can ask the arbitrator to determine that. There is advantages of moving from the mediation to arbitration, include being able to choose your own arbitrator. You can arrange the hearings at your convenience. It's confidential and avoids the court delays. It's also flexible and can be dealt with just on paper. It's a good way to get speedy determination rather than going through the court. There is a further webinar this week for Family Mediation Week on mediation to arbitration. So keep a lookout for that if you want further details on that point. Thank you. Next slide. Oh, I think we've got the next slide up. So, sorry, if you can go back, Katie, I think we've gone to the slide before. Thank you. So, top tips. Elaine, do you want to go first?
Yes, that's great. So top tips: stay calm, think flexibly, and focus on the outcome. This applies to all the participants. So if you're the mediator, make sure that you are doing these things, which I think as experienced mediators we would do quite naturally now. it's about imparting those tips to not only the mediation participants, often your clients, but also you as lawyers if you're working in the hybrid process. Staying calm can be one of the most important aspects, because if you're not calm and you're very wound up, you're not going to be able to think clearly, and you may well make the other person defensive. Thinking flexibly means don't just think of one proposal about an issue, think of a number of proposals, and all the time focusing on the outcome, and enabling people to think about life beyond the mediation process or their dispute. So over to you, Sarah.
So play an active part, have direct discussions with the mediators and be actively involved. Consider professional meetings after joint session, even if you're not present, for a more joined up approach and less correspondence exchanging. Don't send, one of the things for me is in mediations is don't just send off your client to mediation and wait for them to come back from you. Check in with them. Is there anything they can do? Because it needs to run parallel with the legal advice, because mediation is not to replace the legal advice that they need to make reach a resolution. And one thing I forgot to mention earlier as well, when I've just realised, some of the times I do mediations and we come to the end where we need to just reach the terms of the consent order. It's good to then do the hybrid mediation, solicitors be present at that point, just to make sure that we've all got the dedicated time where, especially if time is of the essence and someone's rushing it through, because weeks can go by between sending drafts and things like that, which is really helpful, and just be more active in that role. Elaine?
Yeah. So as you said, Sarah, that aiming for progress, not perfection, having that sense of continual sense of progress, that things don't just come to a stuttering halt, and that as the mediator, you're enabling that, we could say communication. I think that's really important, and to remember that all the time, that the progress is the objective, not just a perfect exercise. So over to you, Sarah.
Language matters. I'm really keen on the language, and I see it firsthand in mediations of how the language used in letters can derail negotiations and how it makes people feel. When you speak to MIAMS about the letters that solicitors have sent, I often see a lot of the letters and see the impact that it has on the other person. So I think just be mindful of the language and how you structure your letters can really help. Think about picking up the phone instead of emails that can be misinterpreted. And often we can have discussions that we wouldn't ordinarily put in correspondence when you're on the phone. And just in terms of when we do letters, the dear sirs, I don't put dear sirs. I try to keep it more personal. I don't use clients by our client, your client. Use the first name, makes it more personable again. And it just seems our client, your client, just seems very positional. And especially if the clients have chosen to deal with matters amicably through mediation, you need to listen to how your client wants to conduct it and just think of how that feeds into the correspondence that you're sending as well while mediation's ongoing.
Yeah, just picking up on that point, Sarah. I often say to people, proposals, it's such a wonderful word, isn't it? Proposal, as opposed to demands. And so I really do try to emphasize that point to mediation participants. So on to the next bullet point, looking for options for mutual gain. Again, working in hybrid mediation, you do have the benefit of holding in your mind the potential proposals that each person is going to make to the other, hopefully. And so you can really emphasize those options for mutual gain and encourage people in terms of timing to make their proposals. That's the timing element is really helpful.
So the other part is the cost benefit analysis. The cost of pursuing an issue needs to be carefully weighed up as to the benefits and the legal fee. Time and time again, I see cases come to mediation and they tell me what the legal fees are that have outweighed the cost of the issue that they're discussing. And I just think just being mindful and just aware of the cost benefit analysis of how things are, and just to refocus on that regularly with clients, because sometimes people get fixated on an issue and actually it doesn't have any bearing on like the financial outcome, or it's just not cost effective to pursue that point.
So with a nod to the great book Getting to Yes, which many of you will be familiar with, these are your BATNAs and your WATNAs. So I always discuss with the participants what their best alternative to a negotiated agreement is and what their worst alternative to a negotiated agreement is. And I ask them to go back to their lawyers and get advice on that, because it helps them in mediation to understand the parameters of what they're negotiating. So BATNAs and WATNAs I find are really helpful, because I think sometimes mediation participants don't think about asking their lawyers this vital question. And of course, that can be one of the things that we discuss in the professionals meeting.
The last one, justice and fairness are in the eye of the beholder, and often participants just want to be heard and their thoughts and feelings acknowledged. I've had so many mediations where they just want an acknowledgement by the other person that they've behaved in a way, or sometimes if it's affairs or something, and you get stuck on that point, and you know, it find out what's driving the issue. And often when you speak to both parties individually, and it goes back to what I said at the beginning of how important the MIAM is, identify the elephant in the room. What is the actual issue that they're not explaining? And I think, you know, in some of the hybrid mediations I've done, but when they've not seen each other, both have left feeling, you know, relieved, and that they don't need to have that closure, and they've come out of an outcome that they can both reasonably live with. Could we just have the next slide, please? So how could it be suitable for cases that you have? So me and Elaine just said it's worth taking a moment to review your current cases and consider whether there might be any suitable for hybrid mediation. Both Elaine and I are always happy to discuss options with legal advisors and explore how mediation could assist. So even before that referral's made to us direct, we could just have a quick meeting with both solicitors present just to explore how it could work and how it would work. And both myself and Elaine have spoke before, and we're happy to do that. And they're really effective, and it just has that more joined up approach again. And if you find yourself caught in a hostile exchange with another solicitor, I just wanted to say, why not pick up the phone? A quick conversation could help identify a more constructive approach to support the separating family and move matters forwards. So on that note, we've only got another 10 minutes or so, and we just wanted to go through some of the questions. So I can see we've had quite a few questions that have come through. If you have any more, then please just pop them in the question box. So the first one is, what professional standards are in place with the FMC for the hybrid process, including training for lawyer representatives? I myself went on the hybrid training course with Resolution, and I know that Family Mediators Association do another course which is not called hybrid, but that they do the same. But there's no actual course to do it. It's more about confidences, and people can all, as a mediator, you can already do this process. It just gives you more confidence, maybe going on a dedicated course to give you a bit more confidence in dealing with it. Do you agree, Elaine?
Yeah, I mean, the family mediation code of practice and standards remain the same, and its hybrid operates within those standards. I think that's what we can say to clarify that. The next question is about cost. Probably now, actually, we could take the slides down, couldn't we? Be good to see everybody's faces. Yeah, so the next question is about cost. Is hybrid more expensive than other NCDR processes, such as conciliatory lawyer negotiation or collaborative law? Well, very often, hybrid mediation means that you cut to the chase so quickly that it's a cost saving, because you're dealing with the important issues as soon as possible. And of course, in hybrid mediation, you don't have to have lawyers there with you. You can access lawyers' advice outside the meetings. So it can be really cost effective. Of course, collaborative law, again, can be really cost effective for the same reason, because you tend to reach conclusions much more quickly than if you were going to court, because that takes such a long time. And obviously, the more time you instruct a lawyer for, the more expensive it's going to be. What would you say, Sarah?
Yeah, no, I agree. And again, it's having that, going back to the MIAM of what are the costs, and just to make sure it's proportionate. And it's so flexible, and it went back to the early neutral evaluation that I was saying, that you could do it as more informal than formal, and again looking at the costs associated.
I think there's a question, Sarah, about cash flow modelling, if you could explain that.
Yeah, so the cash flow modeling is a piece of software by financial advisors that some do, and it's putting in all the information. So when you're looking at like the outgoing schedule, and what their outgoings are, you'd put in of the house that they've got, and if they needed to downsize it, and you put all this information into the software, and then it shows you what it looked like up until retirement age, and then what it looked like till death. And it has different, it's like a bar chart, so it shows you if you'll have enough money to get you through to retirement, or if there's any gaps that you need. So it's really helpful for sort of spousal maintenance to look at needs, and you can put all this information in. There's lots of financial advisors that will do demonstrations on cash flow modeling, so reach out to them and see if it's something that they do. And it's really informative just to see that visually, because it's really hard to crystal ball gaze as to what it would look upon retirement, and you can change the ages of retirement and things like that in, and you can put in information. If you was to get a pension share of X, you'd put that in and see what that'd look like, and it might be that it shows that actually you can have a deficit, but it does take into account things that you might downsize when you get to retirement. You don't need a 4-bed detached house, you might go to a smaller place, and that frees up cash, and it helps you have a bit of a plan and know what the future holds.
Great. Now there's a few questions about training to become trauma informed. So I did my course with the Scottish Law Society, which was absolutely brilliant. And I think there's a bit of a lack of training. I know that people are on that course from across the world. So there were people there from America and from Australia, and I would highly recommend it. I think there's probably a waiting list to do it. And it certainly took me, it was over the course of a few months. It was all remote. And although we had sessions, there was a huge amount of work to be done in between the sessions, but I can thoroughly recommend it. It was excellent. I think that shorter courses are available. I think I saw something on the FMA website about that. So have a look at that. In terms of domestic abuse training, well, again, Resolution provides that. I'm one of the trainers, so courses come up fairly regularly. And I know that FMA also does really good and excellent training courses on that. The next question is about if mediation started and the mediator's unaware of the domestic abuse, is it possible to move to hybrid mediation, and how would the victim survivor go about trying to achieve this? So if it becomes apparent that the mediator is not aware of the domestic abuse, of course, it's always possible to change mediator. And so you could look for somebody who is a trained hybrid mediator and who also has up-to-date knowledge about domestic abuse. So that would involve a change of mediator, which of course we all know does happen. Next question is about early neutral evaluation being binding like a private FDR. Over to you, Sarah.
Thank you. Yeah, the early neutral evaluation isn't binding, but from the ones I've done before, it really helps close the gap between the parties. And it's a bit like if you were doing court proceedings, you have your private FDR and the judge gives an indication, and then you don't see that judge again, and there's that risk. It's the same with an early neutral evaluation. So they'll give you an outcome. It's not generally in a report or anything. It's just having a discussion, and depending on who you instruct, will have different styles with the barristers. But no, it's not binding. But a private FDR isn't binding either, so that
Of course,
helps.
it can be if you move on from from a neutral evaluation, an FDR, to drafting a consent order. So,
Yeah.
Karen, you will receive a copy of the slides and the details for the mediation to arbitration webinar. I think that's Wednesday morning. Is that right, Sarah? You'd know better than I would.
I think so, but if you go onto the Family Mediation Council website, the full timetable's there, and you can sign up and click to get the link on there.
Next question is about can a solicitor be involved in hybrid where only one party is represented? And I know that Sarah and I were having a chat about this just before the webinar started. So, Sarah, what are your views?
Yeah, so I've got a few cases at the minute where the wife has just not been financially aware of how they deal with the finances, where they're not particularly complicated, and husbands, I've just been conscious that they're not on the equal playing field when we're dealing with discussions. So I've done one or two now where one person has a solicitor and the other person has chosen not to. But again, it's making them have that decision. But if I ever felt that it got to a position where someone was jeopardized because of that, then I wouldn't do it. And I know me and Helen might have different views on that. And I think it's each individual case and the affordability of both parties as well.
Yeah, it's about all the time, of course, keeping in mind, trying to achieve a level playing field. Um, but, very much with victims, survivors of abuse, you would probably want to think really carefully about where they're getting support from to deal with, what's can be a highly emotional negotiation for them. Karen has then asked about, will mediators require specific training for hybrid mediation, or will any qualified mediator be able to offer it? As Sarah said earlier, Resolution offers a specific training course for hybrid mediation, which I know when we went on it, we found it of great benefit. And I think if you're going to hold yourself out as a hybrid mediator, especially with resolution, then you would need to go on the course.
And I think as well, it's just to be careful with the agreement to mediate, because you change your agreement to mediate when the hybrid because of the confidences. So you've got to be careful that you make sure everything's covered in that agreement to mediate. And again, if you go on the course by FMA Resolution, they help you and give you a template. So it's about that confidence and feeling comfortable doing it. We've had another question come in about when you find yourself with a hostile opponent solicitor who refuses to temper their letters despite them offering no value whatsoever. What are your top tips for calming them down? This is a really
So we love this one because we've both we're both big fans of BIF. So this is a concept that's come from the High Conflict Institute of America, where I did my training, and it's the great Bill Eddy who helped to found the High Conflict Institute. And Sarah and I have both been fortunate to watch his presentations and get involved with him. So BIF stands for being brief, informative, friendly, and firm. And if you have a look on the usual suppliers, you'll find the BIF books. Bill is a prolific writer. He's written BIF for co-parents, and that's the one I probably recommend the most. The red book is the original BIF book, so that's for anybody. He's also done BIF for the workplace, which I know quite a few of people that I know use in their working lives. And then he's done BIF for lawyers. So that's the one to get, Jake. You've asked that question, is have a look for BIF for lawyers.
Yeah, it is excellent, and they've got a whole range of different books for different things, which are really good. I regularly recommend the one that's for co-parenting, specifically for co-parenting. You know, if you see often on the Our Family Wizard, and I look at the transcript of messages and they don't know how to do them, and that's a really good way to do it. And it's similar with solicitor correspondence as well, isn't it, on both ways. We've had a question from Anita Craig about letter v phone call. I see your point absolutely about the informality time-saving approach of a call to a client. However, as a company, we try to keep away from private conversations to individual clients once mediation has begun. Often it opens the door to misremembered information from the mediator, which could cause issue. I think I'm meaning a call to the solicitor, not the client afterwards. So I would call them together. So I think that's what you mean in terms of if after the mediation I would call both solicitors, and have like a joint Zoom call. Do you think that's what the meaning, Elaine?
Yeah, hopefully that's what
I
Anita is
wouldn't call.
meaning.
I'd do the same. You try not to deal with mediation outside of the mediation session of having separate calls. And,
I
and
think I think we've reached the end of our time.
we have, yes, or we've got lots of other questions. So sorry that we haven't gone through to the other ones. If you do want to ask me or Elaine, any questions, our details, if we could just share that slide. I don't know if it's possible to share that slide up again. Was our details on that last one? Or it'll be all sent to you that has our details, or you can find me and Elaine on LinkedIn, and happy to ask any
Yeah,
questions.
or the
And
FMC website.
Yeah, I'll try have a look at some of the questions that have come through because we've still got lots to get through. And me and Elaine could try have a look at getting a Q&A out as well as like a bit of a blog.
Yeah.
Yeah, there's our details on there that it's just been shared now. So please feel free to drop us an email with your question. I'd be happy to answer it. All
Thank you
right,
so
thank you for
much to
that. And
everybody. Thanks a
yeah,
lot.
hope you enjoy the rest of Family Mediation
Yeah.
Week.
Enjoy the
Yeah.
week. Bye.